Hear ye, hear ye, hear ye. The United States Court of Appeals for the Fifth Circuit is now open according to law. God save the United States and this honorable court.
Good morning. Thank you for standing, Mr. Kallinen. We want to welcome you here. We're glad we were able to reschedule at such an early date. We hope your health is improving. And the case we have today is number 20-40279, Miller v. Dricks. I'm sure you're both quite familiar with our ordinary regulations, so I won't bother you about those, but I would remind you that you are not permitted to video or audio this hearing. It's streamed and recorded as usual. And also we would like you to mute any cell phones or devices that you or anyone with you may have so that we're not interrupted. It's been my practice on my panels to give each attorney 5 minutes uninterrupted for presentation at the beginning if you choose to use that. So with that, we'll call number 20-40279. I think I'm calling it again. Miller v. Dricks, and Mr. Kallinen represents the plaintiff.
I am Randall Kallinen for a plaintiff, Brian Miller. May it please the court. And I would like 5 minutes uninterrupted. However, I probably won't take that. In this particular case, an excessive force case, a video which is a part of the record captures 90% or more of what is important to the underlying merits of the excessive force case that is a part of this action. I believe that plaintiff's brief and their appellant's brief and their reply brief adequately sets out the case law, the recitation of facts. And so, but before I get into that, I want to talk about the grant of a summary judgment due to lateness of a response. And I just wanted to point out that I have been practicing for 26 years, and this is important to some of the case law, and I have never been sanctioned in any court, federal or state, and I have been the solo practitioner pretty much in about 250 cases, which have gone to, about 240 or so to completion. So I have not been involved in any behavior in the past which would say that, oh, look, Mr. Kallinen has been involved in previous behavior like this, so it's about time to sanction. There was no prejudice by my being late in this case to respond to the motion for summary judgment. It was very late. And as pointed out, the only mistake that I made was when I was granted an extension, that extension date did not get on my calendar. And I believe I know what it is. It's because probably it's possible that instead of waiting until I put the date on my calendar, I had deleted or put the email into old mail. I don't do that anymore. Now I make sure that the only way I put new emails into the old email is after I put every date that's applicable, whether it's a scheduling order or anything like that. So that's what I think happened, because sometimes I used to say to myself, well, I'm going to put that on the calendar, and then all of a sudden there's something comes up and I guess I forgot. So that is what I am responsible for. And so I have implemented a new strategy to make sure that does not happen, that I get all the dates down that I should get down. In this particular case, there was no prejudice to the whole case because it was over 4 months from the time I actually filed the response to the motion for summary judgment, that the case was set for trial. And this was not a very complex case. It involves a short issue of excessive force. So I do not believe the court would have taken a very long time to come to a decision on it. And so there was no prejudice to any party. Now, of course, my client is the one who, suffers the most because his case is not heard in the court. So I do not feel that, based upon the case law, I do not feel that, or not feel, I do not believe the case law supports an automatic jump to a motion for granting of summary judgment. So therefore, the plaintiff just wants to have his day in court, wants to go back to the district court and to have the case tried. And once again, since there's a video in this case and the case law on excessive forces, there's a lot of case law in the Fifth Circuit and elsewhere, Supreme Court, on excessive force, which I have the appellants have put into their brief. I think that there's no sense in wasting the court's time and going over just, once again, what's in the brief. So the appellant just requests that this case be put back on the docket of the district court and move forward to trial.
Mr. Kallinen, I guess, is it okay? I'll ask a question. Did your plaintiff ever get deposed?
Yes.
Where's the deposition transcript? Is not in the record, I take it?
No, I don't believe it's in the record. I believe, yeah, I'm pretty sure the deposition was taken. I took the deposition of all of the involved officers.
You did? Well, so what materials did you file when you ultimately decided to oppose the summary judgment?
Okay, well, there was affidavits, an affidavit of my client, and I'm turning to that page right now. Hopefully I have it here. It's in the record excerpts. Well, I'm gonna have to pull that up because
well, if it's in the record excerpts, it's in the record excerpts. I concentrated my preparation on the video, but
well, I mean, Your Honor, it's not in the record excerpts, it's in the record on appeal, but
okay, anything else?
Not for the moment. I could no, Your Honor.
No, I mean, nothing else supported your response to the summary judgment. You didn't
I
have
believe I referred to the evidence of the
video.
The video for one thing, yes, as well as medical records. There were medical records of the broken jaw and the cut to the head. So that was in there as well. And
what part of the head was the cut on?
They said the occipital.
Occipital. Yeah, well, I didn't have time to look it up. It's at the top of the head, the back of the head, bottom of the head.
It's the bottom because I do have a degree in chemistry, Your Honor, and the eye nerves go all the way straight back to the back of the head, and occipital refers to like sight, and so that's where the part of the brain for the sight is. So that's why it's called the occipital.
Sort of the base of the head?
Yes.
Okay.
Was there any evidence of injury from the taser being used?
I mean, when you use a taser, it puts electrical discharge from one point to the other, and there's usually burns on both of them because it heats up when the electricity goes in and out of an individual. That could have been in the medical records. I'm not 100% certain, Your Honor.
When I couldn't tell from the record when exactly Sergeant Masick used the taser. Was it after the first time your client was struck, or the second time, or the third time? It was
after he had been struck 3 times with the butt of the gun on the back of the head, according to the video. You can see it in the video. Plus, you can, if you listen carefully, you can actually hear the thud every time it hits the back of his head 3 times.
Right. I was just asking when the taser was used. After all 3 hits?
After the hits.
Okay.
The whole event took less than 6 seconds, right?
It was for the hitting in the back of the head. Yes, Your Honor. I mean, that portion of the hitting in the back of the head. Yes, that is correct, Your Honor.
And I just was reading in Officer Dricks' affidavit this morning. It says a crack pipe was located in the yard after Miller had gotten out of the truck. Is that correct?
I am not certain about that, Your Honor.
Is Miller incarcerated today, or is he out somewhere?
No, he is not incarcerated.
What happened to the were any charges brought?
I believe they were, Your Honor. I believe they were, and my best recollection is he did serve a short time for a drug charge. That is correct.
But he had a warrant out, and that was the reason for the stop, wasn't it? A warrant? Wasn't there a warrant?
Well, he did have a warrant for his arrest. I'm not sure exactly for what, whether it was a traffic ticket, but I believe that it could have been that or just a traffic violation. I know he wasn't like a suspect in a burglary or a suspect in any sort of major crime.
The briefs say it was a parole violation warrant, a felony parole violation.
Well, he could have been, he may have been on parole, and it's possible, I believe that it was, he did not report to his parole officer. I believe that was the violation, which gave him what's commonly called a blue warrant, I guess, for violation of a parole or probation.
What's your position about the bystander liability against Officer Santos? Do you contend you should have intervened or what?
Yeah, well, on the video, I believe it shows that Santos is looking in that direction. And generally the law says, in my interpretation, is that the officer needs to intervene by words or action. Most oftentimes, if an officer were just to say, hey, don't do that, or quit hitting that guy, or let's just grab his arms, that's usually enough. He's not required to tackle anybody or to start beating on an officer himself. No, nothing like that. But at least by words or action, he is supposed to attempt to intervene. And I believe that although it was a quick time, I believe that he did have time to intervene if he would have acted quickly. Not in the first hit, maybe not even in the second hit, but by the time the third hit in the back of the head with the thud, remember when you're listening, there's a thud to the back of the head so you can hear it and see it. And then there's Dricks, going, ugh, or making verbalizations in pain. So therefore, there was so he got the information that there was excessive force going on.
Okay.
And
have you retained an expert witness for the plaintiff?
In this case, I believe that since there was a video, I don't think we did, because I believe this is one of those cases where you can look at the video and the video speaks for itself. You don't always need an excessive force expert. Most of my cases, I do have an excessive force expert. In this case, I don't believe I got one because I had a video. We had a video.
Well, apparently the defense of Officer Dricks is that he used something called compliance strikes. And I looked up compliance strikes, and, it seems like a matter of expert opinion whether under what circumstances compliance strikes are appropriate.
Well, Your Honor, in this case, there's plenty of case law in the Fifth Circuit and elsewhere that blows to the back of the head are considered, very high level of force. And when you look at the video, my client gets on the ground, or Mr. Miller gets on the ground. He shows his hands first, gets on the ground. He's compliant. He never tries to run, and no one ever says they saw any weapons. So we contend he was compliant. So I don't think in something that obvious we need an expert testimony. I don't think that's required.
Well, he says he hit the upper torso.
I think if you look on the video,
I looked at the video this morning. I couldn't tell for sure. I mean, because it's taken from the rear.
yeah, well, that's where the medical records come in with the cut on the occipital region. And then also you can, on the video, you can hear the thuds and him saying, and you can even see him bouncing up, you know, he's face down, but you can see him like bouncing up a little bit when he gets hit because of the pain and so forth.
Well, of course there was pain. I'm just wondering whether if somebody hits you in the back, you know, somewhere in the upper neck, it might also cause your head to go down, boom, on the pavement. So I think that may be a disputed issue of fact.
Yes, Your Honor. It very well could be a disputed issue of fact, Your Honor.
That's what you're hoping for anyway, right?
Yeah, that's correct, Your Honor. Yes.
What's your best case?
Oh, Your Honor, the best case is probably an old case. I know that the court always asks for my best case, and you know what, I don't. Gosh. I have several in the brief, Your Honor.
Okay. All right, that's fine. You've reserved time for rebuttal.
Thank you.
Mr. Selbe?
Thank you, Your Honor, and may it please the court. Stephen Selbe for the appellees in this case and the individual officers, Richard Dricks, Bradley Masick, and Jose Santos. I am happy to take questions at any time during my argument. One thing that was asked, that I'll clear this up to begin with. One thing that was asked in the argument of my colleague across the aisle was what was submitted in support of the response to the motion for summary judgment. And the answer to that are only the medical records. And I will also represent to this court that you can go through every page of the medical records and not find any reference to any complaint of the plaintiff about his leg. So I believe that my colleague on the other side said that the affidavit or declaration of the plaintiff was submitted. It was not. The response was merely the medical records. That after answering that question, I think that this case divides itself into two distinct areas of inquiry. Area one is procedural and breaks into two subparts, and I will address those because that is how the plaintiff briefed the case. Subpart one of the procedural question is whether or not Judge Brown's use of the word unopposed in a single sentence somehow transforms his carefully considered, well-reasoned opinion into a default or automatic summary judgment. Officers believe that the answer to that question is clearly no. The word of the use opposed does not trump a 9.5-page opinion wherein the district court set forth the facts as presented, a clear recitation of the correct burdens in the case, and a careful and appropriate analysis of the officer's burden in claiming qualified immunity and the reasons why the district judge believed the officer's claims were valid. The plaintiff cites to a single sentence in the opinion. That sentence occurs at the first page of the opinion. That's record 416. And the sentence reads, quote, accordingly, I treat the officer's motions for summary judgment as unopposed. I believe that what that sentence should have said is I treat the officer's evidence as undisputed. After citing to that sentence, the plaintiff then ignores 9 pages of the opinion. Frankly, the parties in this case could have avoided 20 pages of briefing if the judge simply had not used the word opposed, unopposed.
Mr. Selbe, for the sake of efficiency, I'll just mention to my colleagues who may not know this, that Judge Brown was on the Texas Supreme Court before he went on the federal district bench. And before that, he was a partner of Baker Botts law firm, where to my understanding, he would have specialized in federal law. I find it little short of incredible for the suggestion to be made that he did not know the appropriate standards for summary judgment. And therefore, I, for myself, am not willing to credit that he screwed up.
Your Honor, I completely agree. And I think all you have to do is go through the 9.5-page opinion and see that it is exactly the opinion that any district judge would write when considering an officer's motion for summary judgment in an excessive force case. Here, 3 officers' motions for summary judgment. He set forth the burdens. He looked at the facts. In footnote 1 of the opinion, he notes that he has viewed the video and did not find the video to contradict the officer's affidavit testimony, and then discusses excessive force law, qualified immunity law, discusses the Dricks versus Brewer case, which frankly I believe is on point in this case, and is a case that frankly I should have cited in the motions for summary judgment. But the opinion of Judge Brown went through the exact analysis that any judge would go through in considering officers' motions for summary judgment.
So, Mr. Selbe, in your view, the video corroborates the video confirms all the findings of the district court?
I don't think it contradicts it, Your Honor. The video is dark. The lights of the police cars are flashing. The sirens are going off. And so it is both hard to see and hard to hear. But what I do think it actually corroborates that the plaintiff exited his truck quickly, and it gave the officers the impression that that he was going to flee on foot, leaving the truck. And which of course it would,
in connection with that and the facts, the district court said that it was unclear whether Miller lowered himself to the ground or whether Officer Dricks tackled him. I watched the video, and the video to me seems to show that he was already on the ground when Dricks got to him. So if I agree with you that the video was unclear, then perhaps you can agree with me that it's not unreasonable that I could watch it and conclude that he was already on the ground when the officer tackled.
Your Honor,
the district court just said, well, it was unclear whether he was already on the ground or whether he was, I guess, trying to flee.
Your Honor, the district court, I believe, said that because of the deposition excerpts of the plaintiff that we attached in support of the motion for summary judgment. The plaintiff actually testified that before he got to the ground, that Officer Dricks bear tackled him. And I think that, look, interpreting the video is interpreting the video, and what we must do in this analysis is say, could a reasonable police officer have perceived what these police officers perceived? But what I think occurred, and my interpretation is that I believe the plaintiff was going to flee, but he thought that he was going to flee Masick, who was the first officer in line behind him in the pursuit. And what occurred was that Dricks was so much closer to the plaintiff than Masick was, that Dricks surprised him, had a gun on him, and said, get on the ground. And that's what I don't think the plaintiff voluntarily went to the ground. I think the plaintiff was surprised by the presence of Dricks, and then he was commanded to the ground with Dricks pointing a gun at him.
But you agree that the video doesn't clearly show that he was fleeing?
I believe that the video clearly shows he exited the pickup quickly.
And lowered himself to the ground. He was on the ground before he was tackled.
I don't disagree with you. And if you'll read the affidavit of Dricks, Dricks actually says that the plaintiff went to the ground. But I think he went to the ground not as this is on my plan always. My belief is that he went to the ground because Dricks ordered him there. Dricks was much closer to him than he believed that Dricks was going to be. And Dricks ordered him to the ground with his gun pointed at him.
And then he placed his knee on his back, right? So at that point, was he still a flight risk or any threat?
Well, Your Honor, at that point, keep in mind, he has not been patted down. He was not patted down at the initial stop. In fact, he never removed himself from the truck in order to be patted down. And of course, the way he left the pickup, there was no way to pat him down. So I don't know at that point if he is a flight risk, but he is certainly still a danger because the officers do not know if he has a concealed weapon.
And he had his hands under his body.
His hands were under his body, and the plaintiff testified, and this is in the deposition excerpts of the plaintiff attached to the officer's motions for summary judgment. He admitted that Dricks called for his hands. Now, he says that he couldn't get them out, but he couldn't get them out because Dricks was on him. But Dricks has no way to know that he is not complying because he can't get them out from underneath him. So the plaintiff's deposition testimony in this case, I believe, confirms the officer's affidavits in terms of why they did what they did. Officer, I also want, while we're on this point, Officer Dricks, what he testified to was that, and if you watch, it's more of it. These are not big roundhouse blows that he is throwing with the butt of the gun. It's more of a chop, and he intended to strike the upper right shoulder of the plaintiff. And in fact, in his affidavit, that's what he did. Now, obviously, at some point in time, in one of the subsequent blows, in one of the subsequent strikes, he missed. He ended up hitting the jaw of the plaintiff. We acknowledge that, but his intention was to strike the upper right shoulder of the plaintiff with the butt of the gun, once again, in a chopping motion, not in a roundhouse punch. Your Honor, subpart 2 of the procedural issue is whether Judge Brown abused his discretion either in striking plaintiff's response to the motions for summary judgment or denying the motion to alter or amend the judgment or reconsider the decision. Once again, we believe the answer is a definitive no. The plaintiff's original deadline for filing a response was July 19th. The plaintiff requested and received, unopposed, an extension to August 18th. Plaintiff's response was not actually filed until January 17th, 2020, 152 days after the extended deadline. In addition, procedurally, the plaintiff did not file a motion for leave to file a late response along with the response, did not request any relief under Rule 6B, and did not even file an explanation for the late response. After the court granted the summary judgment, the plaintiff did file a motion for new trial / motion to alter / motion to reconsider, but the motion cast only a very light touch to the application of the Pioneer factors, did not in fact cite the Pioneer case, and offered as the only non-conclusory reason that excusable neglect existed was because neither opposing counsel nor the court reminded him that the response was due. I think it's interesting that also in that motion, the plaintiff did not complain that Judge Brown had incorrectly granted a default summary judgment. I don't see this as a big issue, that the plaintiff has presented sufficient evidence in the declaration that was attached to the motion to meet the Pioneer factors. But I would point the court to the Adams versus Travelers case that we cited, where a plaintiff had received a couple of extensions. He filed a motion for summary judgment on the second extension 1 day late, and the court struck the district court struck the response to the motion for summary judgment, and the Fifth Circuit, a panel of this court held that the judge did not abuse his discretion in doing so. And the two cases that the plaintiff cites as support for that issue are in opposite. In the Coleman case, the Coleman-Hammond case. It was an OSHA citation that a company missed the deadline to. And Judge Jones, you may remember you actually wrote this opinion, but they missed the deadline by 18 days. And they set forth in their motion for leave to file it, in their request for relief, they set forth in detail their incoming mail procedure, their efforts that they took, and then once again only missed the deadline by 18 days. The Stoddard case that the plaintiff also cites is a situation where the plaintiff actually filed a notice of appeal, filed a motion for extension to file a notice of appeal within the time period allowed.
Well, Mr. Selbe, I think we all understand all that, and I'd like to turn your attention back to what happened again. I'm curious about this idea that the crack pipe was located in the yard after he was subdued.
It was, Your Honor, and crack cocaine was actually found in the truck.
Well, that's a search incident. That's not as interesting to me, because the video seems to suggest that as soon as he got out of the car, he raised his hands and then dropped to the ground. So when was he able to throw the crack pipe out? That's sort of hard to figure out.
Your Honor, I watched the video 50 times, and I can see the left hand comes up, and then in 1/10, 2 sets of a second comes back down. I never see the right hand come up. So I think in going to the ground, clearly the plaintiff could have had the crack pipe in his right hand, and he's trying to get rid of it. It could have been in a shirt pocket, and it fell out during the struggle. I think it could have come from a variety of places.
Would you be planning to have an expert witness if the
Hear
case went
ye,
to
hear
trial?
ye, hear ye. The United
We likely
States
would
Court of
have, Your
Appeals for
Honor,
the
and
Fifth
our
Circuit is now
deadline did
open
not
according to
pass.
law.
The plaintiff's
God save the
deadline
United
had
States
passed
and this
under the
honorable
docket
court.
control order, and the plaintiff
Thank
had
you and
not
welcome
designated
everybody.
an
We
expert.
are glad to have
Our-
you today. Just a few
our
reminders.
expert designation
You are
deadline
not
was
to
going to be
photograph
December
or
the 7th.
videotape or
February
audiotape
the
this
7th.
proceeding.
And by the way, which I think
Please
is
recall that
is
you
a
should
reason
mute
for the
yourself when you are
prejudice in
not
terms
talking,
of
but
the-
unmute
of-
yourself
of
when you are talking. And
the late filed
please,
response.
when you
But
reference
I do want to concentrate on
facts
use
in
of
the
force,
case, we
because
would
what
appreciate
these
record
officers
sites.
were dealing with
And
was an offender
please
that had a
recall
felony
that
patrol
rebuttal
warrant,
is for
an offender
rebuttal
that
only.
ignored one
And
officer's
with that,
orders to
we will
stop and
begin
several
case
commands to
number
turn your truck off.
20-30240, Miller versus Alliance Standard Life Insurance Company, and we'll begin with Mr. Toledano
It's
for
a
Michael
situation
Miller.
in which this person had not been patted down.
Afternoon.
We didn't know if he
Reagan
had
Toledano on behalf
a
of
gun, a
Ellen
pistol, a knife
Miller.
in the front
Main
of his
issue in this
pants
case
and
whether
under his
the
shirt.
pre-existing
As this
condition
court
clause
noted in
applies to
Poole
Mike
versus
Miller.
Shreveport,
And
that
we
law
believe it
enforcement
clearly does
officers
not,
need to make
for several
extraordinarily quick decisions
the
under
most
tense
important reason
involving
is this policy
unknowable
had a transfer of
circumstances.
insurance coverage.
Arrests are inherently
whereby
dangerous and can escalate
Mr. Miller
precipitously
was to
if
receive
the arrestee
credit
is
for
not
the
overcome
previous time he's been
immediately.
insured
And
on
that's
this
what
plan.
these officers did.
He has been insured on this plan ever since
Yes, we're
Lake
aware of
Charles
that. Now,
pilots ever
Sergeant,
began
did
a long-term
Sergeant
disability
Masick
plan for the group.
in his,
He
and
was the
again,
president
sorry,
for
I
many
haven't
years.
looked
He's
at
always
his
been insured.
affidavit. Does
And
his
in
affidavit
2015,
say
he
that the
had to take
plaintiff had
disability leave. And
resisted
during that leave
stepping
of
out of
absence,
his car during the very first
the
encounter?
Lake Charles pilots decided to switch
Well,
insurers.
it's clear from the
And
video
Alliance
that
Standard
he
began
does resist
insuring the
stepping
plan on
out.
Well, I
September
mean,
1st, 2015.
that part only lasts a few
which was
seconds
at a
as
time
well,
that
right?
Exactly.
was out on
Car.
disability leave
Yeah.
with different carriers
Yeah,
at the time. It was potential.
Officer
He eventually returned to work
Sergeant
and,
Masick asked him to turn the truck off.
Became
And
disabled
that
again,
is the command
and
that
the issue became whether
the getting out of the car
pre-existing
is
condition
going to
clause
be the
applies.
next command, but we can't even get him to follow
The
first
policy
command.
has a transfer of insurance
Yeah, well, he
coverage provision
keeps
that's
talking
set,
about
and
going to
there are
his
several
father's
requirements of that. But one
house,
of the
right?
requirements, and the one that's at issue
He
today,
does,
is
Your Honor,
whether he
that's
was an
what the
active
plaintiff's
full-time
brief
employee on the
says.
day
But
that,
all, and in fact,
Alliance began
there's an
insuring the
allegation in the plaintiff's
Mr. Toledano,
brief
I was not an
that
insurance attorney,
Mr.
so I need
Dricks
to be spoon-fed this. I need you to hold my hand and walk me carefully through this because I get lost.
He says, take it to the house, take it to the house, take it to the house 3
You're
times.
saying
There is no
whether he was
request for
active
Masick to follow him to the house.
is the key part, because
Your Honor,
if he's
I
not
believe
active,
that the
then
Judge
he's not
Brown
an
correctly
eligible
analyzed
person
this under the
with
Graham
respect to the
factors.
transfer
That,
provisions.
that-
Am I
and
following?
that this is a case in
that's
which
correct.
no excessive force
requirement is that he
existed.
needs to be an active
because of the
full-time
seriousness
employee
of
on
the
the date of
offense.
transfer.
And
Okay.
the decision
Right.
by
And
the
just
plaintiff
one other
to
question,
flee
just
earlier, the
sort of
ignoring
preliminary
the
question.
officer's commands,
We're not talking
and the
about whether
officer
he was
safety issue from the
actively
standpoint
at
of
work,
we don't know
which is a
if
defined
this person is
term,
armed because
right?
of what we've done.
because as I
Were
understand
the
it, correct me if
officers
I'm wrong, the
aware
parties
of what
agreed that
kind
he
of
wasn't,
warrant
quote,
was out for
actively
him?
at
Yes,
work.
Your Honor, that is in there.
Such that the first
that he was-
paragraph
he-
of the
he had
transfer
a
provision
felony
would sort of
parole
take
warrant.
care of this.
And then
Is that right?
finally,
What does that
That's right. That's
What does that
undisputed.
mean?
He was
Okay.
out-
that
he
the
was not
violation
actively at work,
underlying
and
the
he-
parole
but he
the
was an
parole
active
violation
full-time
was a
employee.
felony.
And
Well,
the
what,
Sixth Circuit in
again,
Wallace decided
Officer,
literally this exact issue.
Dricks
It was the
says it
exact
was a
same policy
parole
language, it
board
was the exact
warrant.
same
It
factual
doesn't say
circumstances.
felony.
A claimant there was
Your Honor,
out of work
I think
on
Sergeant
disability,
Masick,
just like
who was
Michael
the one
Miller,
who communicated
and
with
Reliance
dispatch will know
denied the
that.
claim, and they said that she was
Real
not an
quickly,
active
because I know
full-time
my
employee
time
because
is-
she was not actively at
well,
work. Actively at work,
because I
as
know
noted by the
my
Sixth
time
Circuit, is a term
is
of art
coming
defined
up.
in the plan, which
I
has certain
believe
meaning.
that under the Graham
But
factors,
the
that no
eligible employee
no
section of the policy does
excessive
not
force was used.
require
However, if you get
being
to, this,
actively
to
at
the,
work, it just
the
requires
clearly
a person being
established
active,
prong of qualified immunity,
full-time employee. And the
my
Sixth
belief,
Circuit
this is the Dricks
concluded
versus Brewer
that
case,
that could include
it
someone
clearly,
who's not retired, someone
entitles
who's
the
still an
officers
employee
to
of the plan, but
qualified
just
immunity
happens
in
to
this
not be
case.
at work that day when the insurance took effect.
Thank you, sir.
Well, I assume from that
Mr. Kallinen,
definition that
rebuttal?
active has to have a meaning
Yes,
independent of
Your Honors, I
full-time.
would like to point out
Right.
a couple of things.
You have to be both
that
an active
was,
employee and a
in
full-time employee.
response to.
That's right.
Okay,
Appellee's
so
counsel.
help me with, I get that active
One
is
of the,
different from the
things
defined
is
term actively at work. I
Mr.
get that.
Dricks knows
Help me with
he's on
how
the
do
back
how should I think
of
about active
Miller. He knows that.
in that,
And that puts a lot of
because
weight
it's not
on
defined
Miller.
in the policy.
And
So what does
furthermore,
it mean?
after he hits him once
To
in
be
the
an
back of the
active
head,
full-time
that's when he,
Well,
at least
one
once, that's
example
when
that
he
comes
says,
to mind is think
show me
about
your
someone
hands.
who's in the
So now
military.
he's been hit in the
They're
back of the head,
actively
very
serving
dizzy,
for the
all
military,
this
but
weight
they
on
might
him.
not be at work
Mr.
on
Miller is
Saturday
not a
because
large guy. If
it's a weekend
you look at
or
the,
they're on sick
when they
leave.
pull him up and everything, he's a
But
small
they're
man.
still active employees,
50-ish
as long
or
as they're
something
not
like that.
terminated
Doesn't lift
employees,
weights or
but they
anything.
haven't retired,
So
they are active.
Dricks should know that
And
his
that is
weight
what
upon
the
the
Sixth Circuit
individual's
found.
back
And
with the
the Sixth
smashing
Circuit
of the
said,
head,
at the very least, it's
is
ambiguous.
going to cause him some
Because, if they really wanted there to be an actively
not being
at
able
work
to pull his hands
requirement,
out,
they should
which
have
is
said so
caused
clearly
by
in the policy.
Dricks.
And they
You
didn't.
should know that.
They just say
He's the one
active
who's on
full-time
his back.
employee.
If I'm on
Well, they kind
someone's
of
back,
actually said the
do I know
opposite.
I'm
I
on their
mean,
back?
that
Of
second
course I know
paragraph
I'm on their
is
back.
expressly
And so you got a
for
lot of weight on
somebody
the
who
back, he
wasn't
knows that.
actively at work.
And if you listen
due to
the
injury or
timing when he
sickness.
says show your hands, it's already after he's hit
Right.
the
That's right.
and this
Okay,
causes
so-
great, dizziness.
It seems like you have the
This
actively at
sounds
work,
very
paragraph
much like a
1, and
fact
paragraph
question
2
about
is
what
somebody
Dricks-
else. Because if
Dricks
you're
knew
actively
and
at
so
work in paragraph 1, you would need
regarding
paragraph 2.
the
Paragraph
expert
2
witness
says,
deadline of the
that blah, 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 but not actively at work
appellants
due to
for
injury or
the
sickness and would otherwise
I
qualify as an
allow
eligible person. So to me, it seems like
extension
active
in all
has
my
to mean
cases, and I
something
would have
other
done saying
than
if there was some extension
me sitting
that
in
the
this
other
chair
side
right now
needed,
where I'm
they
actively
would
at
just have
work.
to ask me, and I would say, sure, have a month,
Yeah,
have
it
2 months.
means, I
So,
believe what it means
You
is
had
what
already
the Sixth
gotten your
Circuit found it to
extension
mean.
without
And also
asking
this
for it.
court
What's that?
decided it meant it in the
You had already
Jackson
gotten
case,
your
which was an
extension
unpublished
without
decision, but
asking for
it
it.
was very similar to the reasoning
that you
that the
missed
Sixth
the
separate employee.
deadline by 5
But
months.
I believe
Oh,
it
no, no,
meant
no,
that
what
you're
I'm
just,
saying
you're
there is
still
there
an
was some talk
employee.
about
You're just
how
out
there was
at the
prejudice,
time,
a
and,
possible prejudice
you
to
can be,
the
as long as you're not
appellee
fired, or
because
you
their
haven't been
expert
laid
witness
off,
was
you are
some
still an active
preparation.
employee.
But
You're
what
just
I was
not there
saying
at that
there
moment because
is,
you're out on sick
just
leave
like,
or for some other reason.
Mr.
Maybe it's the
Selby
weekend,
had granted
or
me an
maybe it's a
extension.
holiday,
I of course
the
would
day
grant
that
him
the
an
insurance took
extension,
effect.
even if he didn't.
But,
I do it all the time. So there was no
I think at
prejudice
best it's
regarding
ambiguous.
expert witnesses. Now, once
and
again, some
under
jurists,
an
or at least
ambiguity
one
under the
jurist
Fifth
over
Circuit
there in the Southern District,
jurisprudence, he should win.
He won't even let you have an expert on
he shouldn't have to face the pre-existing
most of the
conditions
time.
whatsoever.
And so his feeling is that, hey, it's obvious.
The other-
Look at the video. and I
Well,
think
no,
that
you
was one of the
please go
things
ahead
that
if you want to say more about
need,
active.
An expert. witness. So I believe that all of the issues.
I don't know what else to add to that other than it doesn't mean
appellees bring
actively at
up
work.
Is things that a
you know,
jury should look at.
if
They
they
should
meant
look
Did
at the video.
remind me,
see
did
the
the district
testimony
court
of
really
the
address
witnesses
this
and,
idea of
make a
active
decision.
and
Oh, by the
eligible
way, in the
person
medical
and the
records,
transfer?
I
Did the
did get the
district
chance
court
to look those
focus
up
more on the
during
payment of
appellee's
premiums?
Presentation. And in the medical
the
records
district
which
court
were attached, it says
I believe that the district court did
soft
find that
tissue
the
swelling, and then it
that
says
he was
there
not
are two
actively at
fractures.
work. So the
One
court
of the
read into
jaw
a
and one like
requirement that
or the mandible and
he had to
something
be
here.
actively at
So
work.
it's not
the
one
court essentially
fracture,
bought
but two
Reliance's argument
fractures.
at the district court
And then
level,
there's that,
which was contrary to the Sixth Circuit
swelling in the back of the head.
Okay, so there's that
the
issue,
medical
and then the
records
district
say
court did
he was
find
hit
that
on the head.
premiums
I don't
had
see
not
it
been
either way.
paid. I'm probably getting the
Certainly
language
a fact
wrong.
issue. So
that's
I
correct.
believe
The
that,
district court made a ruling that the premiums were not paid, which to
basically,
this day I don't understand why.
I think
First of all,
plaintiff should have
that
his day in
issue
court.
should not have been
We
taken
have a
up by the
video,
court at
he
all
has
because
injuries on
Reliance
medical
failed to
records,
assert it
and I
during the
think it's a
administrative
debate.
process.
That's a debate.
And
I think we should bring that
the
debate
essence of an ERISA
to
case is a
a
review of an
jury
administrative
and
record
let
where
the,
Reliance explains all its
appellant
arguments, we get to
have
rebut
his
them,
day in court.
and then we're back,
Thank
we're sitting at the district court
All
level
right,
almost
sir.
in
Thank you
appellate
very
capacity.
much. And the court will,
here we never got
stand
that
in
because
recess.
Reliance, for the very first time, alleged that the premiums weren't paid while we were briefing the motions for summary judgment. And it simply was untrue. The reason why they never argued this at the district court level is because it was untrue. Reliance knew all along that the premiums were paid. They had the information showing that the premiums were paid. So as soon as they made that argument, which I don't believe the court should have allowed them to make it after the fact, but assuming that the court allowed it, we moved to supplement the administrative record with a declaration from the insurance agent showing that the premiums were in fact paid. And we also provided a detailed invoice a paid invoice that demonstrates that Michael Miller's specific premium amount was included in that amount, and they received the full amount of that payment. I don't know what else we could have possibly, we could all have submitted more, but that was the best evidence we could show that the premiums were paid. And somehow the court said they weren't. The only thing I can think of is the court got a little bit mixed up because Reliance had stated in its brief that the premiums were not paid. And maybe the court took them at their word on that.
And what's weird to me about that is that's something that is clearly within Reliance's knowledge to ascertain. It's not something they can only get from you, like what is your social security number or something like that. They know they were paid the premium. So I'm just confused a little bit by the whole, I guess they're just arguing you had a burden of proof at the administrative proceeding and you didn't meet it, but they didn't say that. So I don't know. I find it a confusing argument by Reliance.
You and me both, absolutely. And the Sixth Circuit was a little bit perplexed by it as well, and they noted in their opinion that Reliance is the one that knows whether the premiums were paid. And they approved two different short-term disability claims for Mr. Miller. And had he not paid his premiums, that would have been the first thing they would have said. They would have said you had no coverage here, and we wouldn't even been arguing about anything about the pre-existing condition because he either would have had coverage or not. And in our appeal, we argued that the premiums were not paid, and there was just no reason to provide any other information because Reliance had all the information. The information ultimately that we gave to the court that showed that the premiums were paid were on Reliance's letterhead. It was basically the paid invoice that Reliance had in its own possession. And Reliance could have simply, asked Reliance's attorney could have simply asked its client, were the premiums paid while we were litigating this issue? But it was just, I don't know, but.
Well, I guess we'll see if Reliance is going to continue to press that argument when they argue. Can I ask you sort of about an order of decisions? Let's assume the panel agrees with you that the transfer provision applies. Do we need to reach the other issues in the case? And I'm thinking specifically about whether the right knee disability is an excluded pre-existing condition, and then about whether the neck and back disabilities are substantiated by the record.
No. Basically, if the transfer of insurance coverage provision applies, then there's no need to get into whether the back or the knee were pre-existing conditions because the pre-existing condition clause does not apply whatsoever. It's not an issue, and that's I mean, these policies are designed this way. They're designed to credit periods that claimants have been insured under the plan before they become insured. And that's exactly what this policy did. And it just so happened that Mr. Miller was out on disability leave on the day that Reliance began insuring the plan, but we believe he still has coverage. His coverage should transfer. It's just, and here's a guy that paid these premiums for years and years and years. He was the guy that started the group disability plan. I mean, this was
the Sixth Circuit. I believe it remanded for further proceedings, maybe for some fact finding. If we agreed with you, do we need to remand?
I don't believe so, because the reason why the Sixth Circuit remanded was because the district court never looked into whether he was a full-time employee. So that was an issue in that case. In our case, in the Miller case, there's no issue of whether he was full-time or not. When he was working full-time. There's no part-time employment for a bar pilot. And there was evidence in the record, which we cited into our brief, that showed that his schedule was basically, I think it was 2 weeks on, 2 weeks off, or some sort of schedule like that. But it was full-time employment. He was working a minimum of 30 hours a week when he was working. That's demonstrated in the pay stubs that are provided. We cited it into our brief. So there's no reason to remand at this point. He was an active full-time employee at the date that Reliance began insuring the plan. He's entitled to his credit for his time towards the pre-existing condition limitation that he had already developed.
Let me ask you this on the premium issue. Is the fact that they did pay the short-term disability some evidence that the premiums had been paid? Your point earlier that insurance companies, I have a lot of experience with insurance companies, and it appears to me that typically they don't offer coverage when you haven't paid your premiums. So would that be some evidence of that, the fact that they had paid those short-term disability, would that be some evidence that they did in fact get paid a premium?
Yes, it would, because that would have been the first thing they would have checked is whether the premiums were paid. And if that weren't the case, they would have denied the claim. It simply was never an issue until Reliance's attorney brought it up in the litigation, and Reliance would have never brought this up because they knew the premiums were paid. And there was the record actually showed that the premiums were paid. There were some claims.
Again, it's a little bit of a technical argument, I think, that they're now claiming, which is that you didn't prove it in the administrative proceeding. So maybe it was paid, but you didn't prove it. And that's why I was asking whether the payment by the insurance company of the short-term disability was circumstantial evidence of the premium payment.
Yes, that's their argument, but it's also, I don't think, a fair argument. He also didn't provide his birth certificate to prove that his name was Michael Miller. There was no reason to prove something that Reliance knows all along. And Reliance never denied the appeal. They never made a decision on the appeal. They just simply ignored it. And that's another factor here. Had he not paid his premiums, it would have been something, first of all, they wouldn't have approved two separate short-term disability plans. There wouldn't have been claims notes saying that the premiums were paid. But they also would, when they got the appeal, they would have denied the appeal saying the premiums weren't paid. And then we could have done something about it. We could have said, okay, well, here's some evidence showing that the premiums were paid that you have in your possession, but we'll give it to you again. But it's simply it was just never an issue. And that's one of the reasons why in an ERISA case, they're not supposed to be allowed to make arguments that weren't made during the administrative process. Because we could have demonstrated this during the administrative process. We wouldn't have had to have moved to supplement the record while we were doing the cross motions for summary judgment at that point. But
okay, I'm going to give you 1 extra minute and your opponent 1 extra minute if you want to cover the knee, neck, back.
Sure. If the pre-existing condition clause does apply, we believe that he's still entitled to benefits under the policy because he did not receive treatment for his right knee or for his back and neck pain during the look-back period. And if you go through the medical records, which we tried to summarize in the briefs and at the district court level, you'll see that he didn't have treatment for those conditions. Now, Reliance argues that there was one medical record, I think from a physical therapist, that said that he was rehabbing the knees at one point at time. It was actually not from the physical therapist. It was from the doctor he was seeing for his wrist pain. And he noted in that record that he was rehabbing his knees. And Reliance is saying that equated to treatment for that condition or consultation for that treatment, which would trigger the look-back clause. But We believe it did not. And because he wasn't even treating with that doctor, and he wasn't rehabbing his knees. He was rehabbing his left knee at the time, but not his right knee. So we believe his right knee is disabling independent of his other conditions. And we also believe his back and his neck pain. He's got significant stenosis in his spine.
Your time is up. You've reserved some time for rebuttal, and we'll now hear from opposing counsel.
May it please the court. Good afternoon, Your Honors. Joshua Backrack, represent Reliance Standard Life. I think it's important to look at the, because your Honors have asked the questions about the coverage language in the policy, the active language. And I think it's important, under ERISA, you have to read language together. And this policy says you have to be an active full-time employee. And full-time is defined as working for your employer for a minimum of 30 hours per week during your regular work week. And counsel didn't address that language, during your regular work week.
Well, so I agree. What was Mr. Miller's regular work week? Was it 30 hours?
Mr. Miller had no regular work week on or about September 1, 2015, because he was already disabled.
But when he was at work, what was his regular work week?
Well, that, I don't know that has been established, because counsel hasn't established that. There's some evidence he worked 2 weeks, then he'd be off 2 weeks. I don't know that, so at what point is it that he did that regularly? Because that's the language, regular work week. So we know in July, as of July 1, 2015, he stops working, and he doesn't work again until 1 year later. So we have a whole year where there is no work at all, 0 hours for that entire span. So to say that he had a regular work week years ago, that doesn't qualify, because the policy looks to, at the time of the transfer of coverage on September 1, 2015, did he regularly work a minimum of 30 hours a week? And the answer to that is no. I don't understand
why you have this second paragraph that says explicitly, but was not actively at work due to injury or sickness on the effective date of this policy and would otherwise qualify. I mean, why are we going to have that if we're requiring that his regular work week be going on right then?
I'll explain it, Your Honor. And it's important, I'm going to put in the context of comments that counsel made. So counsel said that this transfer of insurance coverage protects somebody if they are, quote, not working that day, end quote. And later he said that somebody may be off during a weekend or on a holiday, and this protects their coverage. And that is the purpose, because if a person is missing a day or two at the time of there's a transfer from one carrier to another, this protects them. So if it happens to be during a holiday and they're not working that day, they're going to be insured by Reliance. If they're out sick due to a cold or a flu, they're going to be insured by Reliance.
Okay, but what about if they had COVID and they were in the hospital for 3 months? Would that count?
If their hospitalization began 3 months earlier, and I don't think you have to say COVID, it could be anything. If their regular work week as of September 1, and you look, again, regular. So what does that mean? That means on a regular basis, on a consistent basis. That's what the dictionary, we provided the dictionary definitions of what regular means in our briefs. So on a regular basis, as of September 1, he had to regularly work 30 hours a week, and he didn't.
Yeah, but let's say on July 1, he got COVID and ended up in the hospital, and September 1, he's still there. But prior to that, he had worked 30 years, 60 hours a week. Let's just give that hypo. Why would he not be covered? Why would this not apply?
Because he's not regularly working as of September 1. I believe it's unreasonable to say that in the context of the words active, what active means, and regularly working, which is a definition of full-time, that a person who has not worked in approximately 3 months, and when you look in the aggregate, has not worked in a complete year, they are not regularly working the required number of hours.
But we don't look at the aggregate. We're looking at the effective date. And I guess I don't really understand the purpose of this second paragraph if it's not going to apply to someone who's been, I don't know, I don't remember, he said something like 20, 30 years at this company. He's been there a long, long time, working regularly. Then he gets sick and he's gone for a while. At that point, 3 months or 2 months, I get. Well, was it November? I mean, so was it September or October? Remind me. Okay, yeah, July to, okay, 2 months. So 2 months he had been gone. Where is it in this policy that it differentiates between a week in the hospital for COVID, 2 weeks, a month, 2 months? Where does it differentiate that? Because we have all kinds of people that are in the hospital for several months and then wonderfully they get out and they're back in the world. Some of them pass away, sadly, but that's a real event right now. So why, I mean, how are we supposed to differentiate? Is it the 1 week COVID person, the 2 week, a month, 2 months?
Your Honor, I think you have to look at the language in the policy. The language in the policy is active, which means we cite to a 10th Circuit decision. It means actually working, performing your duties. But then you have to read in conjunction with the definition of full-time, regularly doing that. So you must be regularly working at the transfer date. And this person was not, if he's not working if he's not working in 2 months. And I know Your Honor keeps mentioning COVID. It's regardless of the, maybe that is an issue today in other cases, but that's not the issue here. And I think that just in some ways prejudices the issues in this case, because the transfer of insurance.
If we have to construe the policy, I mean, whatever we issue in this opinion is going to affect future opinions. And so if we were to rule that you could only be off for a weekend or only sick for 1 day, a flu for 1 day is good enough, but a COVID for a week is not, that is going to affect people. I'm not saying, I mean, we have to follow the law whether it hurts or helps people. That's not my point. But my point is it does matter what our construction is. And so I'm just trying to understand your argument, because this notion that you have to be regularly at work is to me inconsistent with the second paragraph that understands you might be injured or sick.
I don't believe it is inconsistent. What they're trying to do is to say if you are injured or sick for a day, for a few days, you're not going to lose your coverage. But Your Honor, there's a days?
If you're writing our opinion, so you're writing the opinion, how many days do we put down?
I would look at the dictionary definition of regular, which is in my briefs, which is regular means on a consistent basis, on a scheduled basis. And when you look at that, this person was not scheduled or consistently working on September 1, 2015 with any regularity because he hadn't worked in 2 months. I don't think, and it's hard to put some temporal meaning except for regular, the definition of regular, which means consistent. And on a consistent basis, as of September 1, he was not regularly working 30 hours a week because he had not done so since June 26th, I believe, the last day that he regularly worked. I don't think a person would say that, I'm regularly working. And by the way, that's a word in the policy. It says full-time means working for your employer for a minimum of 30 hours per week during your regular work week. Not that you have worked in the past for 30 hours a week. And counsel mentioned the Jackson case, which is an unpublished decision. In that case, it involved very different language. That case had language that defined it as working as required by the employer. This policy doesn't.
I have two questions since you're talking about the case law.
Yes,
well, my first question is not related to the case law. What about are you still pursuing the premium issue that we discussed with your opponent, number one? And secondly, with regard to the case law, how do you distinguish Wallace? Would you please take us through that?
Certainly, Your Honor. So as far as the premium issue goes, counsel is saying we waived the issue because we didn't address it. But again, it's his burden. And that was the point I was making. He said in his letter that I paid premiums, but he provided no proof. That's like saying I'm disabled, but you don't give a doctor's note. Judge Haynes, you said, but you should have the information. We don't, because this is group coverage. So the employer submits the premium on behalf of everybody, and that goes to a premium billing unit. And the claims department would have that information. They wouldn't. They would know if premiums were paid by the group, but unless somebody affirmatively states that premiums were paid by this individual, they would not necessarily have that.
Why would you recognize a short-term disability if you hadn't paid premiums?
It was a mistake, frankly.
Twice?
No, because the second claim, so there are two claims, October 23, 2015, and then the one from August of 2016. So let's look at the 2015 claim first. Short-term disability was paid. That was a mistake. The long-term disability was denied on that one for the very reason that there was no coverage. Reliance realized at the time that it shouldn't have approved the short-term disability because he was not covered as of September 1, the transfer date.
The mistake that it has to do with premiums, though, right?
What does it have to do with premiums? Well,
Yeah.
Counsel argued they paid the short-term, therefore they acknowledged there's coverage. That's not true because they denied the 2015 long-term disability claim. There's no waiver here. But what it has to do with premiums is what they look to is have premiums been paid by the employer? And then the employer is the one who says, yes, this person paid premiums or was paying premiums. So
But
we have to rely on what the employer
before you pay
says.
any benefits under the insurance, before your client pays any benefits under the insurance, they are going to check that this person is one of the insured people, at least as far as premiums being paid. If they're not going to check it, then why should we, years later enforce something you're not even enforcing?
Your Honor, they're not checking it, except they are checking it to see has the group paid the premiums. And then if they learn later on, it's an issue. And this is the point I was getting for Judge Engelhardt. It's not an issue. The premium issue part here, apparently there has been information submitted that he did pay it. That hasn't been our defense. In our briefs and counsel saying I've misrepresented to the courts, I have not, and I'm offended by that. But the fact is, we stated from the start that the information that should have been provided wasn't, but that we've never contested it in subsequent briefs.
So just so I understand, is it an issue that this panel needs to decide? In other words, is that a reason why the transfer provision does not apply?
No, Your Honor, you don't need to address it because
what?
He has to prove before. You can't just say premiums were paid, therefore transfer of insurance coverage.
Yeah, I get that.
The first thing you have to show is he's eligible. He's an eligible class.
But right. But so let's say hypothetically we say he's eligible. Is the non-payment of premiums then something we have to decide?
No.
Why not?
No, Your Honor. Because based on information that I will add was improperly obtained by counsel. Counsel contacted my client directly during the litigation, which I have a lot of problems with that conduct, but that information shows that premiums were accepted by Reliance from his client.
Okay, so, look, I mean, I don't want to get into, all I'm asking about, I'm not asking about litigation conduct. I'm asking about, for purposes of this appeal, you concede that premiums paid is not a reason for saying that the transfer provision does not apply.
Yes, Your Honor. Okay. I agree. And we've said that. I believe I said it in the response.
You need to address the Wallace question.
Yeah, can we get to Wallace?
Yeah.
Yes. So that's a good point. So in the Wallace case, what the Sixth Circuit said in that case was that there were no findings by the district court on whether the employer had established regular full-time whether there were regular full-time hours for this person. And since there was no fact finding on the issue of regular full-time, that issue was remanded back from the appellate court. But in this case, and one of, I apologize, I don't recall who, one of your honors had asked whether there was a decision on that issue in this case. And there were specific fact findings, and we cite to them towards the end of our brief. But there were specific fact findings by the district court in this case on why he wasn't, in fact, an eligible person, part of that being that he was not an active full-time employee regularly working 30 hours a week. And the court mentioned the fact that he had not worked since late June of 2015. The court mentioned the fact that he was out of work due to the disability and did not work again for quite a period of time.
Okay, let me ask you this though. Why would the language then be, okay, was not actively at work due to injury or sickness on the effective date and would otherwise qualify? So if he was not sick or injured, he would otherwise qualify. If he was not sitting in the hospital, if he was not sitting at home injured, he would otherwise qualify. Why doesn't that take us back to the moment before the injury or sickness?
Your Honor, that goes back to the point, and maybe I'm not saying it as well as I can, and I hope I do better now. So if he was injured or sick the day before, August 31st of 2015, if he is sick on that date or it's a holiday, and so on the next day, the coverage comes into effect and he's not at work that day, he's not going to lose coverage. But it was never intended to have somebody who hasn't worked in 2 months. So what happens if he's still paying premiums, Your Honor, and he hasn't worked in 2 years? Is he still regularly working?
I mean, y'all write the policy. You can certainly say otherwise qualify for this many months, this many days, whatever. But to me, otherwise qualify means if he weren't injured or sick, he would have been an eligible person, yada, yada, yada. And so that seems to me that you don't count the time he's injured or sick, and you look before that. And before that, he started in 1989 and has been working there for 26 years or something like that. I'm not very good at math, but something like 26 years. So that would seem like he otherwise would qualify had he not been injured or sick. Otherwise qualify, yeah. So that strikes me as, if you all wanted to be specific that the injury or sickness had to be only a week or something like that, you absolutely could put that in there. And I respect that. I very much respect the right of insurance companies within the law, obviously, to write policies how they want to. But that otherwise qualified, to me, makes no sense if we're going to say the day he was injured or sick, he still has to be working full time and regularly and all that, but we won't count that one day, we only count the day before, whatever, because I just don't see that in here.
Well, Your Honor, you're saying you have to look at before. And before, for 2 months, he hadn't worked at all. So he was not regularly working a minimum of 30 hours a week. But I think you also have to look in the context, and I'm trying to find the exact language in the policy on where the otherwise comes. And you have to, it says that a person they still have to be in an eligible class.
Okay, where's the word still?
No, I'm adding the word still,
Okay.
but
I'm
the
just
language is
reading
there
it.
that they have to be in an eligible class.
Okay, I get that, but what I'm trying to understand is, but was not actively at work due to injury or sickness on the effective date and would otherwise qualify. What does the word otherwise refer to here?
Let me just look at it briefly, Your Honor, so I can answer that. So I believe this goes back to what I was saying. So if they are out due to injury or sickness on the day this policy is to go into effect, and that's what it's talking about, on the day prior to this policy's effective date, right? If they're not there, their coverage under some interpretations might have ended. They may not have transferred here. But what this policy is saying, though, but if you are if you're an eligible person, you will still remain covered as long as these three other parts are covered. You satisfy them as well. And what are those three other? Those three other parts include the payment of premium, had been insured by the prior carrier. That's all fine. You see, part of what's going on here, which is kind of interesting, is if he was already disabled, and we know he was from Prudential, why is he even paying premiums? Most people wouldn't be paying premiums, but he is here. So then you have to look at, but is he still eligible? Because the payment of premiums alone doesn't guarantee coverage. He has to be an eligible person. It says would otherwise qualify as an eligible person.
I think
what you're doing is you're saying
Counsel, I think we all agree that where we need to look then is whether he is an active full-time employee under the eligible class provision. And we've talked a lot about what full-time means. We haven't so much talked about what active means. But I guess going back to Judge Englehart's question, we have a Sixth Circuit opinion that I think is addressing an identical policy language. And it says these two terms, active and full-time employee, are ambiguous. And so therefore there are multiple ways they could be interpreted, but we need to interpret them in favor of the insured. Now, do you say that the Sixth Circuit was incorrect in that decision so that, I guess, effectively we create a circuit split? If we just...
Well, there's already been a circuit split on the issue of what active means with the 10th Circuit. And actually the Sixth Circuit, in another case, said active means actually working, a case called Turner versus Safeco. So they've created their own little split within their circuit. And on other issues, this court has disagreed with the Sixth Circuit, whereas this court has said that the term occupation, regular occupation, is unambiguous under de novo review, and the Sixth Circuit has held otherwise, the Second Circuit. So there's already splits. And I think in this case, what you have to do is look at what's reasonable. And is it reasonable to conclude that a person who's not active or actually at work, if I may finish, Your Honor, is not actively at work or actually at work, has not been for 2 months and is not again for a year, can they be considered actually working regularly on a full-time basis? And I think the answer to that is no.
Okay, and I want to be fair to you because we took all the time with the question number one. I want to make sure you have, I'll give you another minute to cover the knee, neck, back argument.
Thank you, Your Honor. I appreciate that. So with the right knee, we know that in 2016, he had both right and left knee replacement, total knee replacement. In June, during the look back period where he had to be treatment free, he's telling a doctor that he has worse pain, especially with rehabbing the knees. So at the very least, he's consulting with a medical specialist for the knee. But that's not the only one. Counsel said that's the only record. It's not. We cite to its ROA 1001 and 1005, where he's telling his physical therapist that his knees are stiff. So he's complaining and consulting about his knees. As to the neck and back, on page 16 of counsel's reply brief, he cites to 10 records. 9 of them are from 2015. They don't prove a disability in 2016. The only other one says there's a history of low back pain and neck pain. History doesn't mean a present issue. So I thank you for your additional time, Your Honor.
Okay, thank you, counsel. We appreciate your argument. And Pam, if you would give Mr. Toledano 6 minutes. So, okay, go ahead.
Thank you, Your Honor. So a couple things here. I wanted to touch on this regular work week requirement in the policy. Full-time is defined as working for a minimum of 30 hours during a person's regular work week. That's true. And what that means is when you're healthy enough to work, you are working a minimum of 30 hours a week. And Michael Miller was working at least 30 hours a week when he was working.
But how do you respond to Mr. Bachrock's concern about, somebody who, let's say, is in the hospital for years or home with an injury for years, and now all of a sudden wants to claim that they are a transferred insured? I mean, is there some sort of time cutoff, and how do we deal with that?
There isn't, as the way the policy is written. I think we have to look at the policy language, and if they wanted to cut it off at some certain time limitation, they could have done so, but they didn't. So I don't know how we can just make one up at this point.
Now, there's this issue of the full-time and all of that. Has there ever been any argument that the fact that for 2 weeks he's sort of 24 hours a day on and 2 weeks he's off, has anybody argued that that's not full-time?
No, Your Honor.
Okay. And that's just the way that's set up for everybody? I mean, so nobody would be full-time, at least no pilot would be full-time?
Pilots, they all work the same. And if you look at the record, the administrative record at 882, or record on appeal 882, and 885, those two bait stamps, there's an explanation of how pilots work. And it's 2 weeks on, 2 weeks off, and they're working 24 hours a day when they are working. And we also provided a list of days that he was working, so you can see his schedule. And he was working at least 30 hours a week, so he was working full time. And so I don't think that's an issue in this case.
You're saying averaging out the month, it'd be 30 hours a week.
That's right. And this court looks at this case from a de novo perspective, applying the same standards as the district court. So the court can look at these record documents and find that he was a full-time employee. I don't see a need to remand this matter.
Well, then why didn't the Sixth Circuit decide it if this is just something we can all just look at the record and make a decision?
Yeah, I don't think the evidence was in that particular file, and I'm not sure. I'm not familiar with the record and what was actually in there, but that's what they decided to do in that case, though. But Judge Guidry did not address this issue. I mean, he never addressed the issue of whether Miller was working for a minimum of 30 hours during his regular work week. And it was just not the issue that he was focused on in this case. And so this was never decided by the district court.
Well, why even have the phrase eligible person if we're not going to look at the guy's situation that day or around that day? That's really Mr. Bachrach's bottom line argument, as I understand it, is we're looking at the relevant day, and he hadn't been to work for 2 months at that relevant day, so how's he an eligible person? That's his argument. What's your response?
Right. I mean, he's trying to read an actively at work requirement into the policy that's just not there. If that's what they wanted, they needed to say that he needed to be actively at work on the day that Reliance began insuring the claim, but the policy simply does not say that. And the Sixth Circuit recognized that in Wallace, this court recognized it in Jackson, albeit unpublished. Insureds get the benefit of the doubt when there's an ambiguity in the policy.
The hard part for me is it's pretty clear what is trying to happen here. The employer is trying to switch insurance companies without messing up its employees. And that, I guess, is not always perfectly done. But to me, that if you back up, transfer of insurance coverage is the title, that's what is happening. You've got an employer who decides that Prudential is too expensive or not working out or whatever, gets a better deal with Reliance, wants to move everything over, but wants to kind of keep everybody in the same cubby they were in.
That's exactly right. That's exactly what this is for. And they were very well aware of the issues. That they actually met with one of the Reliance representatives and discussed Michael Miller's specific situation because they didn't want anything to happen to his insurance coverage in the event he came back to work and there was a change of who's going to be responsible for this. And they said everything was going to be fine. And they were really blindsided when the claim was denied based on this pre-existing condition because he thought he had the credit for that, which he should have. Is it appropriate for us to consider that title, transfer of insurance coverage, or should we only consider the other words that we've been talking about, the otherwise, the eligible person, regular, active, full-time? I think you can consider the transfer of insurance coverage. I mean, that's what this was designed to do. All these group disability insurance policies that I've seen have this. They give people credit for the time incurred towards the pre-existing condition limitation credit. And that's what this policy was designed to do. It's a little bit cumbersome, the wording of it, and it's created some issues as we've seen in the Sixth Circuit and now here at the Fifth Circuit. But I see no reason to create a circuit split. I mean, this is literally the exact same facts and the exact same policy language. What about the 10th Circuit, though? Your opponent said we already have a circuit split. It's not exactly the same factual circumstances. I don't believe that was briefed in Reliance's appellee brief. I think he's talking about the Turner case, but I don't remember the specific facts of that, but I know there were some factual differences and there were differences in the way that policy was worded. Okay. Well, your time is up. We'll take a good hard look again at it. We really appreciate both sides' arguments. Very, very well done. Appreciate that very much. The case is now under submission, and we will excuse you from the argument. Thank you, Your Honor.
Thank you, Your Honor.